So moving on to our agenda today, we have two bills on the agenda today. We are going to take the bills in reverse order. So at this time, I'm going to open up the hearing on Assembly Bill 158. Assembly Bill 158 revises provisions governing criminal procedures for certain juvenile offenders who are also victims of certain crimes. At this time, I would welcome Mr. Dold, if you'd like to come to the table here in Carson City. And I know we have Assemblyman Hambrick in Las Vegas. Assemblyman, it's great to have you joining us this morning from Las Vegas, and whoever would like to go first with the presentation, please proceed.
Good morning, Mr. Chairman and members of the committee. For the record, my name is John Hambrick. I have the privilege of representing Assembly District 2. You have, I'm sure, in front of you copies of AB 158 and some of the exhibits. I'm going to cut my time short. I've got a bad habit of going too long. I want to avoid this so your attention will be focused on Mr. Dold, who has a unique history in this body in fighting the crimes of human trafficking and youth issues. But with that, Mr. Chair, with your permission, I would like to turn over this time to Mr. James Dold and have him go forward. And should there be questions, I'd be more than happy. But I'd rather turn my time over to Mr. Dold.
Okay, thank you so much, Assemblyman Hambrick. And Mr. Dold, it's nice to have you back in the Assembly Judiciary Committee. I think, if my math is good, I think this is probably the fourth session you've worked on issues in this building mostly with Assemblyman Hambrick. So welcome back to the committee, and please proceed with your presentation.
Thank you so much, Mr. Chairman. And let me just start and say thank you to you as well. You've been a champion on children's rights for many, many years. And even before your time in the legislature, we worked together. And I remember you were marking on my lapel pin that you gave me many years ago when we worked to end life without parole sentences for children. So I just want to say thank you for your human rights advocacy on behalf of vulnerable children here in the state. And to Assemblyman Hambrick, who's been a longtime champion for children's rights as well. So thank you so much, Assemblyman Hambrick, for introducing AB 158. It's a really important piece of legislation. And again, my name is James Dold. For the record, I represent the organization called Human Rights for Kids. I'm the president and founder of that organization. Human Rights for Kids is dedicated to the promotion, protection, and advancement of the human rights issues on behalf of children, particularly vulnerable children in the justice system across the country. We also focus on elevating the voices of those who've been particularly harmed by human rights abuses within the system, whether it be the education system, the justice system, the child welfare system. And for me, this issue is particularly personal, as some members of the committee may recall from prior testimony that I've given, but I am actually a survivor of child sexual abuse and child labor trafficking. During the 2013 legislative session, Assemblyman Horn, along with current Speaker Jason Frierson, when he was the chair of this committee, championed legislation that criminalized what happened to me as a young boy growing up in Las Vegas. I was 13 years old when I met the person who became my abuser and exploiter, actually at a Boy Scout fundraiser function. Unbeknownst to me, she was a child predator and began to groom me from the time I met her. I was a kid who grew up in the inner city, and we didn't have a lot of money, and so when this person began to take me out to dinner and to movies and began listening to me and the things that I was going through growing up and the struggles that I was enduring, I grew particularly close to her, and I actually developed a traumatic bond. And slowly over time, like many child predators, she isolated me from my parents, convinced me to run away, and I actually left my home. And for about a year and a half, I lived in her home, where I endured sexual abuse, statutory rape. And because of this traumatic bond that I had, I also was willing to do anything that she asked of me, and that included labor and services. So every time I left school, I would go back to this house where I would take care of children, where I would cook, clean, and for all intents and purposes was a victim of domestic servitude. And I think it's really important to note for children who go through these sorts of experiences where they have been groomed and the relationship with an adult has been sexualized and they've been sexually abused in this way. When we talk about traumatic bonding, it's really about this misplaced sense of loyalty that you have and this feeling that you're willing to do anything for this person because you feel like they're the only person that actually cares about you. And so that's how I ended up in the situation that I did. And over the years, as I began working on issues to advocate on behalf of child trafficking victims, as well as children in the justice system, I began to see all of these different intersectionalities and the need to address the system holistically. And so the bill that you have before you today, I think, is a great example of that intersectionality. It was inspired by a case by a young woman by the name of Sara. Unfortunately, Sara could not be here today to tell her story, but I want to share her story with you to elevate her voice in this, because what happened to her is nothing short of a human rights abuse, and she was failed at every level of the system. You should have in your exhibits also an op-ed that Sara penned a couple of weeks ago that appeared in the Las Vegas Review-Journal, detailing the story of her case and what happened to her. Sara, like many child trafficking victims, was a young girl, 11 years old, when her pimp found her. He began to groom her and sexually abuse her from the age of 11 to 13. And then when she was 13 years old, he forced her into prostitution in California. So from the age of 13 to 16, this little girl was forced to have sex with men for money day after day after day, being raped repeatedly. And Sara had what was known, what we call a gorilla pimp. This is a pimp who is particularly violent. She endured all sorts of forms of torture. And I remember 9 years ago when I first got her case file in front of me, going through her case and just being in tears at what this poor girl had to endure. When she was 16 years old, she ran away from her trafficker for a week. She then entered into an agreement with an older adult male to go and rob and kill her trafficker, which she did. And so then she was subject to prosecution for first-degree murder. So this little girl, who from the age of 11 years old, before she even left elementary school, who'd been raped just about every day of her life, and who had killed the man who had abused her like this, was now facing the possibility of dying in prison. And when she was convicted, and at sentencing, this is 1994, at sentencing, the judge looked her in the eye and told her that she lacked moral scruples, and then sentenced her to die in prison. When I learned of Sara's case in 2010, I'm sure like many of you now, I was horrified at the prospect that a person who had been so harmed by a man and who had acted out and killed him, that our response to that would be to sentence her to life without parole or any sentence in the adult prison system. In every sense of the word, she was a victim. And so I got involved in her case, and with her attorneys at Perkins Coie, we were able to convince Governor Schwarzenegger to commute her sentence, which he did, and she was paroled in 2013. I wish I could tell you that Sara was the only case like this. Unfortunately, this is a far too common occurrence, particularly for girls of color across our country where they're so easily disposable. Many of you have probably heard of the case of Cyntoia Brown. Cyntoia was recently, her sentence was recently commuted by Governor Haslam of Tennessee as well. Similar circumstances, Cyntoia had also a gorilla pimp by the name of Cutthroat, who forced her into prostitution for many years. And then she killed a John who had picked her up and was attempting to rape her. And again, the system's response to that was to sentence this 16-year-old little girl to life with parole after she served 51 years. There's another little girl in Ohio currently serving a life with parole sentence after 20 years when she participated in a crime where her pimp was killed when she was only 15 years old. This is a far too common occurrence in this country, and we need a new legislative framework to make sure that judges have all of the tools at their disposal when these cases come in front of them so that they can fashion a more equitable and a more just sentence. AB 158, we call it Sara's Law because it was inspired by Sara. What happened to her was a human rights abuse, and we want to make sure that that never happens to any child here in the state of Nevada. To go through the parameters of the bill very quickly, on page 2, there's some legislative findings that make clear that these children who commit crimes against people who have previously sexually assaulted or trafficked them are to be deemed victims. We recognize that in some of these cases they've committed serious crimes against their perpetrators. But as you consider all the testimony, I also want you to think of this question in the back of your minds. That if Sara was your daughter, or Centoya was your daughter, or if Alexis was your daughter, what would you want to have happen? Part of the legislative findings makes clear that these children who are victims of sex trafficking or sexual assault who commit crimes against their abusers should not be subject to lengthy prison sentences, but should instead be treated as victims and receive appropriate treatment and services. In Section 1 of the bill, specifies that if a court finds by clear and convincing evidence that during the previous year leading up to the commission of the offense by the child, the person whom the offense was committed against trafficked the child or sexually assaulted the child, the court may depart from any mandatory minimum sentence, suspend any portion of an otherwise applicable sentence, or transfer the case back down to the juvenile court for proper adjudication. I want to make sure that everyone's aware that this language is very tight. Again, a judge has to find by clear and convincing evidence that this person was in fact abused, sexually abused or assaulted or trafficked by the person before they can depart from the otherwise applicable mandatory terms of imprisonment. There might be some criticism that anybody could come forward and make such a claim, but the law already accounts for this in self-defense, right? If somebody kills in self-defense, it's not a get-out-of-jail-free card. They still have to prove that, in fact, they acted in self-defense, right? So the same thing is evident here. The person has to prove that they were trafficked or sexually assaulted by the person. And clear and convincing evidence is a pretty high standard. And again, we're talking about a very narrow subset of victims, child trafficking victims and child sexual assault victims. And the other thing that I'll note, too, is that if the judge makes that determination, all it means is that he or she has more options. They don't have to depart from any mandatory minimum sentence. They can still impose the otherwise applicable term of imprisonment. So really what this bill is about is giving judges greater discretion when these sorts of cases come before them. Unfortunately, in our society, harm against children and that are perpetrated against children is a far too common occurrence. In the United States, Child Protective Services estimates that roughly 63,000 children are sexually abused every year. About 1 in 9 girls and 1 in 53 boys under the age of 18 experience sexual abuse or assault at the hands of an adult, 93% of which is a person that the child knows. In 2015, the National Center for Missing and Exploited estimated that there were approximately 100,000 children in the United States who are exploited through prostitution every single year. And again, going back to this concept of traumatic bonding, it's so important to understand the mental state of these child victims at the time that they commit their crimes. They've undergone a prolonged process of grooming, of being completely deprogrammed and dehumanized to the point where they're willing to do anything for this person. And as a result, they deal with a significant amount of trauma, which fundamentally alters how they perceive events and how they respond to them and what we should expect of them in those situations. We're not trying to exonerate anybody of culpability here, but it is a question of how do we respond when the most vulnerable people in our society are victimized and then commit crimes against their victimizers. Currently, there's an inadequacy of the self-defense claims. So when we look under NRS 200.200, for killing in self-defense, it must appear that 1, the danger was so urgent and pressing that, in order to save the person's own life or to prevent the person from receiving great bodily harm, the killing of the other was absolutely necessary, and 2, the person killed was the assailant or the slayer, endeavored to decline further struggle before the mortal blow was given. So one of the complications with these cases that we see sometimes, like in Sara's case or Centoya's case, is that we see these kids act with premeditation. So in the actual moment that they commit the offense, they're not under necessarily physical duress or threat for their lives. right? At other points during the commission when they were victimized, they might have experienced that. But oftentimes, what we're seeing is that these kids commit these crimes premeditatedly. And so that is why this statute is necessary, this change in the law is necessary, to provide an added layer of protection for children in these situations. I'd be remiss if I didn't mention how the U.S. Supreme Court over the years has weighed in on the fact that children are fundamentally different than adults, particularly in the criminal justice system, and our need to treat them differently. In Miller v. Alabama, Montgomery v. Louisiana, and Roper v. Simmons in Graham v. Florida, the court has said over and over that the distinctive attributes of youth diminish the penological justifications for imposing the harshest sentences on juvenile offenders, even when they commit terrible crimes. I can't think of a better example of where a different type of logic and a different type of policy is needed than when we're dealing with children who've committed crimes against people who've abused them. Also, in a case called JDB versus North Carolina, the court weighed in on the need to treat children differently for purposes of Fourth Amendment search and seizures, because they're different in the way that they view their interactions with law enforcement are different as well. So again, the law here has been evolving over the last 10 to 15 years to recognize children as fundamentally different from adults and the need to have greater protections in place for them. So as I wrap up here, I just want you to have that question in the back of your mind, that if Sara or Centoya was your own child, how would you want them to be treated? Wouldn't you want a judge to have more discretion in cases like these so that they could create a more just and fair outcome? Nelson Mandela once said, "There is no keener revelation of a society's soul than the way in which it treats its children." What does it say about our soul, then, if we allow children who've been sexually assaulted and sex trafficked and who kill their abusers to be sentenced to decades in prison? Today, we are asking you to set a new standard to protect the most vulnerable children in Nevada. We failed these children too many times. Let's not fail them again. In this body, you can make sure that we don't pass up that opportunity. Pass AB 158 and send an unmistakable message to child victims everywhere. We see you, we hear you, we will protect you, and we love you. No bill that you consider, in my estimation, may be more important than the one you have before you. And with that, I'll be happy to close and take any questions. Thank you, Mr. Chairman.
Okay, thank you, Mr. Dold, for your presentation, and thank you to Assemblyman Hambrick. At this time, I'm going to open it up to questions from committee members. I will have some, but I want to let other folks ask first. So we'll go to Assemblywoman Hanson first.
Thank you, Chairman. Thank you for being here, and greetings, Assemblyman Hambrick. It's good to see you. Would we be the first state to have this legislation?
Yes, Nevada, James Dold for the record. Nevada would be the first state. There are similar provisions that have been enacted in other states. They're usually within the context of mitigation. So, for example, in California, there's a particular statute for victims of domestic violence when they commit crimes against their abusers, and it's meant to be a mitigating factor that's considered by the court at the time of sentencing. And so this would make Nevada the first state to sort of open up and give judges more options when sentencing kids in these situations.
Assemblyman Roberts.
Thank you, Mr. Chair. Thank you for bringing this bill forward. It really makes a lot of sense on all fronts. I just have one question about number two, the item number two, when you're added language there on page 3. Is if the person is less than 21 years of age, deem the person to have committed a delinquent act and or transfer the case to a juvenile court or proper disposition. Can you explain the mechanics of that? Is how would a 20-year-old be adjudicated in a juvenile court setting for a serious offense. How do you envision that would work?
Yes, James Dold for the record, and Assemblyman Roberts, thank you for the question. In the drafting phase, we actually meant for that to be under the age of 18. I think in drafting, they made it 21 in the event that you had a 17-year-old, and then at the time that they were convicted, so that the court could maintain jurisdiction and transfer them into the juvenile court system so that they could maintain jurisdiction until they were 21. And so, I know that this has been an issue that the District Attorneys Association has brought up as well. One of the things that we've talked about is a potential amendment to make sure that if the child has already sort of gone through the juvenile justice system and the juvenile court has waived them into adult court, only making the subsection, the first section there, applicable to them. And so subsection 2 would only apply in the event that you had a 16 or 17-year-old that was direct filed into the adult court. That way the judge, again, would have more options to send that child back down into the system. But the idea, again, is if, particularly in that instance where you've had a child who's been direct filed, that the court would be able to send them back into the juvenile system.
So just to clarify, if I may, so your intent is to do an amendment to change that to 18?
Yeah, to make sure it's
Okay.
under the age of 18.
All right, thank you.
Additional questions from committee members? Assemblywoman Miller?
Thank you, Chair. And thank you so much for being a survivor and being here to help other people survive as well. And Assemblyman Hambrick, good to see you, and thank you so much for always being a tireless advocate of protecting children and making sure that, that will be your legacy for sure, is your lifetime work of protecting children. My question is, just to ensure that we are encompassing everything here, it's a two-part question. One, will it include all forms of sexual assault and sexual trafficking, including children that are victims of child pornography? Also, when we talk about accusers, rapers, abusers, sex traffickers, pimps, whatever terms we're using, the offender, will this include regardless of relationship to the child, including if this is a parent?
James Dold again for the record, Assemblywoman Miller, thank you so much for the question. So with regards to the last, your second part, yes it would. So again, if the child shows by clear and convincing evidence that this person had sexually assaulted or sex trafficked them, that defense would also apply to them, so they would be able to benefit from that. With regards to the first part of your question, I struggled mightily when we were working on developing this language. So this bill was before this committee last session, and I know that one of the issues that was raised was that it was kind of broad. Because we looked at it, there's lots of instances where you might want to give judges more options when children are victims of crimes and commit an offense against their abuser. So what we tried to do was take into consideration the concerns that the District Attorney's Council raised last session and say we're just going to focus on child sex trafficking victims and child sexual assault victims to make it a very, very narrow bill and just in those very specific instances. And so to your question, it is just limited to those offenses.
Okay, thank you.
Assemblywoman Tolles?
Thank you, Mr. Chair, and thank you so much for bringing this forward. Thank you for bravely sharing your own story. And another member of the committee already asked my question in regards to the actual proposal in front of us. So I just wanted to make a comment on the record in the preamble that there's some statistics that are given, and I think it's important to add to the record that some of those statistics have been estimated to be even higher, that the CDC has estimated that it's 1 in 4 girls and 1 in 6 boys that are sexually abused before the age of 18. And I think it's really important that whenever we have this discussion, that we acknowledge that a lot of times we give examples of females who've been abused, but to recognize that there is also a very high statistic of males that have been abused, and to not forget the transgender community as well, that oftentimes are a target in exploitation and abuse. And so I just want to make sure that we're acknowledging that there are many, many victims, and that there's also estimates that only 1 out of 10 will actually ever report. So I appreciate you bringing light to this issue. I appreciate you sharing your own story, and thank you for supporting this legislation.
Additional questions? Vice Chair Cohen?
Thank you, Chair, and it's good to see you both, and thank you both for bringing this forward. So my question is that, so you mentioned that we're giving judges tools, which is good, but what are we doing to train judges so they understand what's going on with these children, so that no judge in Nevada ever says to a child like Sarah, you don't have any morals? Because that's horrifying. But I want to make sure that the judges, it's more than just that they have this, it's that they understand what to do with it.
Again, James Dold for the record. Assemblywoman Cohen, thank you so much for the question. I will say that I know that the National Council of Juvenile and Family Court Judges, that's based here in Reno, in Reno, not here in Carson City, actually does a lot of training with judges, juvenile court judges in particular, around this issue, and so it's something that I've been in touch with them in the past on. With regard specifically to Nevada and the training that's going on with the judges here, I'm not equipped to answer that question. I know that there are some really phenomenal judges like Judge Voy down in Las Vegas who sees a lot of these cases and does a lot to raise awareness within the judiciary about these issues, but in terms of sort of widespread trainings, I'm not familiar with what Nevada is currently doing.
Okay, thank you.
Additional questions from members? I don't see additional. Mr. Dold, I had a couple of questions more on the kind of nuts and bolts of the bill. And I guess the first question I had was in Section 1, you talk about the 1 year immediately preceding the commission of the offense. I just wondered if you could shed some light on how you came up with 1 year, because obviously it could have been 2 years, 3 years, could have been 6 months, but just give us a little bit of the history of how you arrived at 1 year.
Again, James Dole for the record. Mr. Chairman, thank you so much for the question. As folks might be familiar on the committee with me, we try to work really, really hard to address the concerns and questions that come up from all of the interested stakeholders. So the 1 year time parameter was, again, an effort to put into place some additional protections that the District Attorneys Association had raised in the last legislative session. I think there was concern that, you might have a child, and again, this sort of isn't our, personal perspective, but trying to address the questions, there were concerns that people might be coming back 5, 6 years before a crime had happened and committing an offense, and sort of not wanting to necessarily give credence to sort of the idea of like vigilantism. And so we tried to sort of put that provision in there to address the concerns that were previously raised.
Thank you. And then the next question is, Section 1, I guess really Section 1 is the heart of the bill, but this procedure that's put into place where there's a hearing essentially, or the person has to prove by clear and convincing evidence, I just wondered how you envision that happening, because what the provision says at the beginning is if a person is convicted. So we would have a conviction first, whether it be a trial or a plea agreement. And I guess my question is, have you put any thought into how and when a judge would make this determination? Do you envision it would be like a pre-sentencing hearing or a motion that would be made? Or would it be everyone arrives at the sentencing and sort of brings this up? So just from a practical perspective, if you could shed some light on maybe your vision for how the process would work.
Absolutely. Thank you again. James Dole for the record. So it would be post-conviction. So the way that I would see it is sort of like during mitigation proceedings as well. It'd be a motion that's filed by the defense. They would present evidence that would show that the person was a victim of trafficking or sexual assault by the person who was the victim of the crime. And then if the judge found that, in fact, the person was the victim, then that's where they would open up more opportunities for sentencing. So there would have to be that finding after the conviction had happened, based on a motion by the defense.
Great. And I think the last question I had, it relates somewhat to what Assemblyman Roberts had asked on subsection 2 of Section 1. And I think your testimony was you intended to reduce that age to 18, and that would apply to juveniles who were direct filed in the system, so that maybe you have a 16 or 17-year-old who was maybe they were in the juvenile system, but essentially their case got put into the adult system. And so here is a little bit of here's the question, I guess. The beginning says you're convicted, and then subsection 2 says that a judge could essentially declare that it's a delinquent act and transfer the case back to a juvenile court. So that's a bit of an oddity because we have, I think, what is a conviction in adult court for an adult offense, and then a judge saying, well, I'm going to now declare this a delinquent act and send it to juvenile court. So the question is, would that conviction, would the adult criminal conviction stand on the person's record, or is your vision of this that a judge could essentially say, this should have been a delinquent act in the first place, therefore you're going into the juvenile system and you're not going to have an adult criminal conviction on your record? And I know that's a mouthful, and if you don't have an answer right now, that's fine, but I just wanted to bring that out, that there is maybe an inconsistency there in the procedure.
James Dold again for the record. Thank you so much, Mr. Chairman. Yeah, and that's actually the latter approach is what we had sort of envisioned, was that, you know, if the case was appropriate for adjudication in the juvenile system and the judge felt, based on all of the facts and the circumstances of the case, that it wasn't appropriate for this child to have the conviction on his or her record and be sent to prison, then they would have that ability to send them into the juvenile court system. So, yes, so that the latter is the approach that we envision.
Great. Did my questions draw any additional questions from committee members? Okay, it doesn't look like it. So again, I want to thank the two of you. I want to thank the two of you for presenting the bill. At this time, I'm going to open it up for additional testimony in support of Assembly Bill 158. This time, Mr. Dold, I'd invite you back up to the table here in Carson City. Assemblyman Hambrick, if one or both of you would like to make concluding remarks on Assembly Bill 158, please proceed.
Mr. Chairman, if I may, I will defer to Mr. Dold. Several specific and technical questions were raised by the opposition. I'd rather him answer it. I think my response, should I be allowed the time, would be more policy. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Again, James Dole for the record. You know, and I want to go through and address what the district attorneys have said here, because I think there were a lot of good questions. And, you know, I'm good friends with John Jones and Bridget Duffy, and I appreciate the work that they do. And sometimes you have to disagree with your friends and let them know when they're wrong. And they are wrong on this issue. And this is a human rights abuse to sentence children to decades in prison and not give judges the ability and flexibility to create a more just outcome. There's no other way to slice it. And it's not a good excuse to say, well, we just don't have the system, so let's sentence a child to decades in prison. That is not a good answer to that question. And Assemblywoman Miller, you raised a couple of good points, and I want to go through a couple of the things that the DA said specifically. So one, in the very first part of their testimony, they talked about AB 218, which was passed during the last legislative session, that authorizes judges to depart from mandatory minimums for child offenders up to 35%. That is a really good bill, and that applies across the board to any child who is transferred into the adult criminal justice system. However, those are also children who have specifically committed acts of violence against any individual. So not necessarily the person that harmed them. We are talking about a very unique subset of people, of child victims who have been sexually assaulted or sex trafficked, who commit crimes against their abusers. So the fact that a 35% departure may be warranted for any child in the adult criminal justice system is a great policy, but it's not enough for children who commit crimes against their abusers. So I think that argument falls flat. The other issue that was mentioned was the fact that sometimes children are transferred into the adult system and then they're there. Nevada also has reverse waiver. So once a child has been transferred into the adult criminal justice system, a judge in the criminal proceedings can transfer them back, right? So the fact that, you know, a judge might make that determination after the fact, again, is something that the judge should have the discretion to do. This is already something that judges can do in the adult system. I also want to specifically go through some of the things that Ms. Duffy said specifically. Again, sort of, these are very unique cases. And all we're talking about is giving judges discretion. right? So it may very well be the case that a judge looks at all the facts in front of them in a particular case and says, you know what? What happened was horrific. What happened to this victim was horrific, but I don't think the juvenile justice system is the appropriate venue. What I'm going to do instead is impose whatever sentence they would have otherwise imposed and suspend all but 5 years, or depart from any mandatory minimum. You know, we have a criminal justice system that has two sides, prosecution and defense. The judges are the ones that are supposed to be implementing what are the just outcomes in those cases, not the district attorneys, with all due respect. And so what we want to do is we want to make sure that the judges have all the tools at their disposal to make sure that they can fashion an appropriate outcome in those specific cases. And I also want to go back to Assemblywoman Peters, what you had mentioned, and I should have clarified this in my initial testimony. When I was going through and talking about the fact that children might sort of engage in sort of a premeditated sort of offense, I meant that specifically from a legal nature, sort of how the system views them currently. It's how girls like Centoya Brown, it's how girls like Sara Cruzan, it's how girls like Alexis Martin, whose case only happened 4 years ago in Ohio. So we're not talking about a decade, a case that happened decades ago. This was a prosecutor within the last 5 years who looked at a 15-year-old girl who participated in a crime where her trafficker had been killed and said, you know what I'm going to do? I'm going to pursue a life sentence for you. It's a human rights abuse. There is no other way to look at this. And so, we remain open to continuing to work with the District Attorneys Association to address their concerns, but on the law and on the policy, and I think some of the rationales that they've brought up in terms of, wanting to maintain the status quo, they are wrong. And we would urge you to vote in support and pass this bill to send an unmistakable message to the Sara Cruzans, to the Centoya Browns, that their lives matter, and that when they commit a crime against somebody who's done that to them, we are not just going to throw them away and send them to rot in a cage. It's a human rights abuse. So I urge this committee's support and make Nevada a national leader. Send a message to the entire country that what happened to Centoya, what happened to Sara, was not right. And we're going to make sure that it never happens again to any child here in the state of Nevada. Thank you.
Okay, thank you so much, Mr. Dold, and thank you, Assemblyman Hambrick. I'm now going to